Everyone's in good form, making FE1 videos, and we're still wondering where the cats are. Videos, 2022 version. Okay? Okay, put you down now. So, hello everybody. Welcome back to Law Hero. My name is Jen and I'm a Fiduciary with the law, among other things. And today we are kicking off our FE1 recap. I do this biannually, annually, what I think is important to study for the FE1s. Now, some people have been posting videos starting with C and night before notes, and I actually watched them all and they just weren't as good as my videos, I'm just saying. So, you know, can't beat the original. And today we are starting with company law. Everyone knows it's my favourite, and I have some updates for all of you. Now, we have had our October 2022 FE1 paper. I'm not going to talk about that today, nor am I going to talk about the exam report because it's not yet out. We're in November. The FE1 results will be coming out soon. We're instead going to focus on the March 2022 paper and examiner report because, yeah, that's what we have at our disposal. FE1 company law is very straightforward. There has been a tendency in the last while for like a higher failure rate. This is because the questions are always the same and the examiner is getting tired of people not answering the questions properly, so the examiner's tolerance has gone down. That being said, the exam reports for company law are extremely prescriptive, but that doesn't mean that you're going to pass the exam. And indeed, in the last year, especially when I've gone into law firms and trainees have said to me, I did everything Tom Courtney asked for in the exam report. That's not enough, because then you would simply just learn the exam report and anyone could do that. The exam report is just, sorry, my voice is gone. The exam report is simply like a recipe. You know, if you were making a cake, there would be some variations to the recipe. There would be some things you'd do yourself. Maybe you'd have a little bit less flour, a little bit more sugar. I don't bake at all, so don't take my word for this. You may add in a pinch of raisins or almonds, depending on how you're feeling. And it's the same with doing the FE1 exams. There is no one, like there's an exam report which is prescriptive, but at the end of the day you're baking the cake. So let's get into company law. Saki, shh. So the first question he asked in March 2022 was the classic one around section 31. A statutory predecessor of section 31 of the Act has been described as giving rise to a statutory contract of the most sacred character. Now, I'm not going to do every question on this paper, but what I'm going to do is show you with this question one how I would approach that. So number one, taking everything we know aside, this is an essay style question, and in the FE1, if you're answering an essay style question, you need some academic commentary, or you need to have done some reading around the topic to get high marks. That's why I say, if you're caught for time when you're studying, only answer problem questions. Indeed, in the contract law paper, there has only been problem questions asked. If I was an alien and had landed on this planet and had to sit FE1 company law, the first thing I would get is my Companies Act, and I would look up section 31. And like, see how relaxed I am doing this? Now, I know I'm a little bit more experienced than you, but this is how a solicitor would act. Okay, so section 31 is the effects of the Constitution, okay? Subject to the provisions of this Act. So that just means that without prejudice, or if any other part of this Act overrules this, you have to take that into account. The Constitution shall, so the Memorandum and Articles of Association have now been called the Constitution since the Companies Act 2014. The Constitution shall, when registered in the CRO, bind the company and the members. So the company is the separate legal entity, the made-up entity, it's not a real thing, and the members are the shareholders of it to the same extent as if it had been signed and sealed by each member and contained covenants by the company and each member to observe all the provisions of the Constitution and any provision of this Act as to the governance of the company. In plain English, that simply means that the company, as well as its members, are bound by the Constitution and the Companies Act. Then the second part of Section 31 says, for the avoidance of doubt, the reference in subsection 1, what we've just read, to any provision of this Act as to the governance of the company includes a reference to any provision of this Act that commences with words to the effect that the provision applies, save where the company's constitution provides otherwise. So what that simply means is that the Act applies unless the Constitution disapplies it, or otherwise contains a qualification of the provision's application by reference to the company's constitution. Fine. All money payable by any member to the company under the Constitution shall be a debt due from him or her to the company. That basically means that you have to pay up your subscribing share. And 4, any action to recover a debt created by this section shall not be brought after the expiration of 12 years after the date on which this cause of action accrued. That just means there's a statute of limitations under which the members can be pursued for their debts. Okay, so now let's go back to the essay question. A statutory predecessor of Section 31 of the Companies Act has been described as giving rise to a statutory contract of the most sacred character. So the reason they're saying a statutory predecessor is because obviously Section 31 hasn't been tested in the courts yet. It was only its predecessor that was, and it says it gives rise to a statutory contract. So a statutory contract is one which arises by operation of law, and here the law is the Companies Act, and we know that by virtue of Section 31 the Constitution becomes a statutory contract because Section 31 says that the Companies Act applies to it unless the Constitution disapplies the Companies Act. Of the most sacred character. So if you think to yourself, what are they getting at here? The most sacred character. When you think of something sacred, it's something that's impenetrable. It's something that cannot just be done away with. It is, you know, it lasts a long time. It's put on a pedestal above all anything else. And what that means is that it is not vulnerable to attack, this constitution. And we know this because a constitution can only be amended by a special resolution. And, you know, for a special resolution, you need 75% of the members to agree. So we know that it is very difficult to change the constitution. We also know that when the Act applies, and mostly the Act will apply, you know, it'll only be very complicated constitutions which disapply the Act. When the Act applies, that means that company law applies, and that means you're on the hook for director's duties, returning accounts, you know, any basically company law compliance issue, everybody is on the hook. And that is the downside of being incorporated, but it's also the upside because creditors are protected, the members' investment is protected, and the company also has a chance at surviving because its constitution keeps everybody in check, and it means that the shareholders have to cough up whatever they owe to the company. So that's the sacred part of it. If you read down through the marking scheme, like some of the things the examiner says is very broad. Like for example, candidates are specifically required to explain the nature and effect of Section 31 of the Companies Act, and that's kind of what I've been doing there. And now what you would then do is go down through the case law, like Clark v. Workman, then talk about the enforceability of Section 31, qua member, that means only enforceable by and against members in their capacity as members. You may, if you remember, talk about Section 25 of the 1963 Act, which was the predecessor of Section 31. You would also talk about, so he's listed a few cases here: McMahon v Irish Road Haulage, Hickman v Kent, Rayfield, LEV Positive Government, Bailey v New South Wales. These are all in my notes. And then he says, finally, candidates might explain the difference between the statutory contract in Section 31 and special contracts between the companies and their members. For example, Bailey v New South Wales and Barry v the Medical Defence Union, and Lissavard Sales v Winnamwana. It's Irish and I can't even say it. Wind farms. That's hard to say. So yeah, that is an example of an essay question. Now, the next one I'm going to do is an example of a problem question, and that is question 2. And it's a problem question concerning the duties owed by a receiver to a company. Now, I've done this countless times, and I've actually corrected a few people who failed this March 2022 exam, specifically this question, which has been asked countless times, so I'm not going to reinvent the wheel. My chapter on receivership in my ebook covers the duties of a receiver very well, but from what I can see, people had learned the notes off by heart, but had never actually gone to part 8. I think it's part 8. Yeah, part 8 of the Companies Act. And this is again like what Tom Courtney really hates, it seems to me, is people who don't know the Act well. And in fairness, he has a point. I mean, the guy basically wrote the Act, so if you don't know the Act he wrote, that's kind of shabby, you know. So if you go to chapter 3, powers and duties of receivers. So that's section 437, 438, 439, and like the funny thing is, people only really focus on 439, the duty of receiver selling property. But if you think about it, I would say 437 is actually quite relevant. And also you would mention that usually there is an appointment of receiver deed or agreement, and in there might be more prescriptive list of obligations than are in the Companies Act, as well as all the case law. That is all in my ebook. So what I would say is happening is that people know the case law very well because it's in the ebook, but they don't know the statute very well. So my big tip there would be to brush up, indeed, in all areas of company law, and spend a lot of time with your baby. I've been saying it for many, many years, so much so my voice is gone. Now, the next part of this video is going to be some updates in company law, which I would like you all to include in the next iteration of the exam. So the first one is, and I'm sure you've all seen this. So there was a recent ruling called Keating v Shannon Foynes Port Company, 2022 IEHC, so High Court 505. And it looked at the legal limits of ministerial powers to intervene in the board matters of semi-state companies. The legal principles underlying the judgment have broader application and should guide directors in balancing their obligation towards the company while acknowledging external influences on company policy. Because of course, when it comes to a semi-state company, the ultimate shareholder is the state, but directors owe a duty to the company, but more than likely the directors that are put on these semi-state boards are appointed by a minister. So it's like they have a conflict of interest. So this case, Keating v Shannon finds poor company is a very good example of the conflict a director will face in the context of a semi-state company. So I'm not going to go to the ins and outs of the ministerial policy around running a port, whoever it is, Department of Fisheries, I guess, something like that. Oh, Minister for Transport. Sorry, should have known that. I'm not going to get into that. What I'm going to get into is this conflict of interest and this duty to act in the best faith of the company, because the director's principal duty is for the good of the company, and this is obviously a fiduciary duty owed under Section 228. As we all know, we know Section 228 very, very well. So the director has to act in the best interest of the company. So the court said that it has long been the position at common law that directors stand in a fiduciary relationship to their company and accordingly owe duties to the company. Fiduciary just means that the director is the legal, protector or manager of the assets or the goodwill of the company. The members of the company are the beneficial owners, so it's like those assets are held on trust by the directors to manage, and they do that for the best interests ultimately of the shareholder, but also for the company. And it's all about the longevity of the company, ensuring the company stays solvent, ensuring that it's, it's trading, it's able to pay its debts as they fall due, not to the detriment of creditors or the wider public, to stay profitable and economic. The overriding rule is that a company director owes the Section 228 duties to the company and the company alone, and we all know that. In certain cases, the director may owe duties to other parties, as you will see in my ebook, but we're not discussing that now. Section 228 allows the director to have regard to the interests of shareholders who appointed the director to the board. And this was the Minister for Transport here. So the court held that in exercising their discretion not to pay a performance bonus to the plaintiff over several years, the director took a course of action which they themselves considered was not in the best interest of the company, solely on the basis that this was what the shareholders wanted. This unquestioning adherence to the wishes of the shareholders could not constitute a valid exercise of the director's discretion. So the directors, in not paying this bonus to the plaintiff, Foynes, whoever it was, Foynes is a place in Limerick, Jen, what's wrong with you? Keating, they literally just followed their shareholders' direction, and it seems from this judgment they didn't have any independent debate, or they weren't making their decision for the best interest of the company, they were making their decision with regard to their shareholder. Ultimately, the court found the director's actions constituted a breach of the plaintiff's service agreement, which caused damage and loss to the plaintiff. As the court put it, unquestioning adherence to the wishes of the shareholder cannot constitute a valid exercise of the director's discretion. This was a breach of their fiduciary duty to the company to act on its best interests. The judge noted with approval the comment of Courtney, that the net effect of Section 224 and Section 2281H of the Act is that directors are obliged to have regard to the interests of employees and members, but the recipients of the statutory favour may not themselves enforce the director's duty. Okay, so that's that one. And then finally, and it's similar because now, on a similar note, under the EU Preventative Restructuring Regulations 2021, there will now be a wider ambit and interest shown to the creditors of a company. So let me just explain. So one change introduced by the regulations, which has attracted the attention of commentators, is Regulation 4, which amends the 2014 Act by including a new Section 224A into Part 5 with immediate effect. And you might remember we just discussed Section 224 there. A director of a company who believes or who has reasonable cause to believe that the company is or is likely to be unable to pay its debts within the meaning of Section 5093 shall have regard to the interests of the creditors, the need to take steps to avoid insolvency, and the need to avoid deliberate or grossly negligent conduct that threatens the viability of the business of the company. 2. The duty imposed by this section on a director shall be owed by them to the company and the company alone, sounds familiar, and shall be enforceable in the same way as any other fiduciary duty owed to a company by its directors. Additionally, and with immediate effect, Regulation 5 introduces a new duty into Section 228, which is directors' duties, which is called Section 2281I, in addition to the duties under Section 224A, having regard to certain matters with the company is unlikely to pay its debts. The directors must have regard to the interests of its creditors where the directors become aware of the company's insolvency. Oh yeah, Regulation 7 of the new regs introduces a new Section 271A into the 2014 Act, which provides that a director may have regard to early warning tools to allow them to prevent insolvencies. The Corporate Enforcement Authority, which is the new name for the ODCE, is charged with introducing an early warning sign system. And what that will mean is they are going to create a list of potential early warning signs that a company may be in financial difficulty. They will give information on restructuring options available to companies facing financial difficulty. And apparently this goes on in other member states. So on the basis of those two parts which I have just outlined, I think you will be in very good shape for your FE1 coming up. The law has changed and I will need to update my notes based on that. But yeah, if you need anything, please contact me, info.lawhero.eu. Follow along on Instagram, and lawhero.eu is where you can get all my company law materials. I will see you for the next one, which is contract law.